Hey everyone, it's Carol Williams back on another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. I am the managing attorney with the law firm Williams Immigration, and as you know, I'd like to dive right on in each Monday morning. So the first thing I'm going to talk about is not H-1B or H-1B cap season. I know that is stunningly surprising. I'll talk about it later though. But the first thing I want to talk about is the rule that we are expected to see published later today that would extend employment authorization documents when you are filing for an extension of your work authorization or your EAD. Right now, it is your work authorization is automatically extended 180 days. The new rule, which we anticipate will be published today, would extend that to 540 days of automatic extension of your work authorization. We are hopefully going to see this printed today. It is because work authorization documents or EADs are taking so long right now to process. And there's a large group of people that are going to be up against a wall, and they're going to be without work authorization fairly soon. So there's been quite a bit of pushing and cajoling and conversations with USCIS to try and get this done. So once it gets published today, which is what we're hoping, we'll all be very happy about that. But I just wanted to let you know that is coming down the pike today. The second thing for this morning, medical exams. So when you are in the United States and you are applying for a green card, you need to have a medical exam. That medical exam looks at, whether or not you've got any communicable diseases, whether you've had all your vaccinations, all sorts of things. So usually there is an expiration date on that medical exam. And again, because we are looking at such lengthy backlogs in processing green cards, the USCIS has come out and said that effective immediately, all medical exam reports that were signed by the civil surgeon on or after November 1st, 2023 are valid indefinitely. They do not expire. So if you have had a medical exam that was signed on or after November 1st, 2023, it is valid indefinitely. So previously we were running up against issues where they were only valid for a certain amount of time. The processing times were taking so long, people would then have to get another pet medical exam. So whether you're party of one or party of five that's applying for a green card, that always stalled your application process while you had to get that second medical exam. So as of now, you don't have to. So that is good news for us. Next thing I wanted to talk to you about, more in the line of efficiency and streamlining the process with USCIS, is there were changes made to the Form N-400. The N-400 is the form we use for naturalization and citizenship applications. So previously, what would happen is once you got your U.S. citizenship approved, you went to your oath ceremony, everyone was all very happy. Then you had to run around to different agencies and update your status and potentially update your name if you changed your name. Now, with the new form, USCIS is trying to make some of that running around to different local offices a little bit easier. So with the new form edition, which was live April 1, so last week, you now have the option of checking to say whether or not you would like a Social Security number, whether you need an original number, whether you need a replacement card, and it authorizes basically USCIS to have that conversation with the Social Security office so that hopefully your new Social Security card is just sent out to you without you having to go to that office. So that's hopefully one less office that you'll have to go to and alert them that you're now a U.S. citizen once that happens. So again, that is now a new option on the revised and updated N-400 form for U.S. citizenship applications. So we're back to H-1B lottery. You knew it was going to happen. You absolutely knew it was going to happen. So the initial lottery has been run. It has been completed according to USCIS. According to USCIS, they believe they have enough. They believe they have selected enough of the H-1B lottery registrants to meet the cap, which is 85,000, 20,000, 20,000 of which are set aside for those individuals who received a master's degree from the United States. So there were a ton of glitches in announcing the chosen registrants. So if you haven't checked your My USCIS account, go back in and do so. Click all the buttons. I'm just telling people, click all the buttons and make sure that your submission has not moved from submitted to selected. If it says submitted, you were not chosen in the H-1B lottery. If it says selected, you were chosen in the H-1B lottery. So this is the initial round of selections. We do not know if USCIS will be running a second lottery again this year. The past few years they have, but they may not run this. They may not run a second one this year. I would not put all my eggs in that basket of a second lottery. So check your USCIS account. If you were not selected, now is a wonderful time to start thinking about your plan B. So just keep that in mind. But if you were selected, you can file online this year, or you can file using traditional paper. If you opt to file using traditional paper, understand that they are not then going to load that information about your application into your My USCIS account. The reason they have stated is because it is the first year of the enhanced accounts. And so basically they just kind of want to fix one thing at a time, essentially. They want to kind of work with one new thing at a time, as opposed to trying to do all the new things all at once. And seeing the glitches that happened this year, I think that's probably a very good idea. So if you were selected, you can file between April 1st and June 30th. You can file your full H-1B application. So if you were not selected, let's talk about possible Plan Bs. Some or all of these may apply to you. Some or all of them may not apply to you. But oftentimes when folks are not selected in the lottery, I have what I call a Plan B conversation with them. And so very common Plan B or alternatives to the H-1 cap for some people are continuing as an international student and getting a different degree, continuing working for your same employer, same job, same desk, same everything, because you're still on OPT and you have either, a full year of OPT left or maybe another 2 years of OPT eligibility left, and you can then enter the lottery next year. Some people qualify for more than one visa category. So some people apply or qualify for more than the H-1B, but for strategic reasons, maybe we chose an H-1B. So now it's time to look at those other visa categories that you may have initially qualified for. Working for a related company overseas for a year or more. If that is available to you, that may be an option. Understanding full well that you do not want to leave the country. I get that. I totally get that. From an employee perspective, from an employer perspective, I understand that. But if there's no H-1B available because you weren't selected in the lottery, and that is the only option by which you all remain working together, that may be your only option. For some folks, buying into or investing in a U.S. business is an option. We have investor visas for that specific reason. And for some folks, unfortunately, their only option is going to be to return home. And that's always the unfortunate part of the H-1B lottery, but it is a very real part of the H-1B lottery for many individuals. So if you haven't started thinking about your Plan B, if you were not selected, now is certainly the time to do so. Next up that I want to talk to y'all about today is the new filing fees. So those government filing fees took effect April 1, so last week. Again, my prediction is that because my colleagues and I raced to file as many applications as we could before that April 1 deadline. My non-existent crystal ball tells me that we are looking at more backlogs upcoming. So we'll see what happens with that. We'll see what other efficiencies USCIS comes up with to help themselves and us through the backlog. Important to know, now that the fees have gone up officially, and we're a few days into these new fees, be careful when you are filing some of your forms. Some of the forms changed on April 1 with no grace period to using the old form. Usually there's a bit of a grace period where you can use the old form because we forget, we've already got the forms filled out. Immigration is really quite empathetic to that. But this time, no. There are some forms where those new forms had to have been used April 1. So just keep that in mind and make sure that we're all using the correct form date, or immigration has said they will send the entire application back to us. So keep that in mind with the new fees that went into effect last week on April 1. Next topic I want to talk to you about is marijuana and immigrants. So April 20th is coming. It is a day that is celebrated by folks that use and or advocate for marijuana and all of its derivatives to be legal. Marijuana and the intersection of immigration is never a good look. It's just not. Although many states have legalized the use of marijuana under various circumstances and various conditions, the federal law has not. So under the federal law, cannabis, marijuana, and the use and possession is still very much not legal. It is still not authorized. It is still not okay. So if you are here and you're an immigrant and you're here on a temporary visa, or you are wishing to obtain your green card, you want lawful permanent residence, stay away from all forms of cannabis, marijuana, all of it. That is one of the quickest ways for USCIS to deny an application. It does not matter that your state may consider it to be lawful. So you just want to steer clear of it all together. You don't want that to be the only thing standing in between you and the job of your dreams, or you and, moving your family to the US for forever and ever and ever. So that is my message to you in advance of 420. So, I always end with a national interest waiver tip. National interest waiver, as we know, it is a green card category. It is a second preference green card category. It is for those individuals that have at least a master's degree or higher. If they don't have a master's degree or higher, then they need to show that they have exceptional ability. Next, they need to show that their proposed endeavor, their proposed work, their proposed career path has substantial merit and national importance to the United States, that they are well positioned to advance their proposed endeavor, and on balance, it is beneficial to the United States to waive the usual second preference employment categories. Those second preference employment-based green card categories are basically a labor certification application, which requires there to be an employer who is sponsoring the application, and for that employer to advertise for qualified U.S. citizens for that role. So the tip I have today, I get this question often, is how long does it take? What does the process look like? Very high level. The national interest waiver, it's a two-step process. The first is the national interest waiver. The first is that I-140 application where you are showing USCIS that you meet the national interest waiver requirements. That is, the proposed endeavor has substantial merit and national importance, that you are well positioned to advance that endeavor, and that on balance, the United States needs to waive those requirements, and you have a master's degree or higher, and if not, that you can show exceptional ability. That's the national interest waiver. That is step number one. So once you get that approved, then if you're in the United States and you're able to, you can adjust your status. That application At the end of that adjustment of status, once that application is approved, then you are a green card holder. If you are outside of the US and you are applying for a national interest waiver green card, instead of filing an adjustment of status, you would then work with the consulate and have a green card interview at your local consulate. So it is a two-step process, whether you're in the United States or outside of the United States. So just keep that in mind. Once your national interest waiver I-140 is filed, you are not done. There's a whole process after that. So I have been getting that question quite a bit lately, so I thought I would tackle it here Monday morning with you all. So that's all I have this Monday morning. Have a beautiful rest of your Monday and a great rest of your week, and I will be back next week with more U.S. immigration updates.